Dear students, welcome to EPG Pathshala. Today we shall be discussing Water Prevention and Control of Pollution Cess Act 1977. We all know water is essential for the survival of human beings on this planet Earth, and the state is owing a constitutional duty to provide clean and pure water not only for the domestic use by the human beings but also water for commercial and industrial uses by various consumers. Since water is essential for survival of living organisms on this planet Earth, and the instances of pollution in water, they increased, the world woke up to this challenge, and accordingly to cope up with pollution, environmental pollution in general, and various types of pollution like water pollution, air pollution, efforts were made at the international level. At international level, Stockholm Declaration is a watershed in international environmental jurisprudence, and the same is true about Indian environmental law and jurisprudence. When the country committed itself to the goals of sustainable development under the Stockholm Declaration, the country also enacted various legislations to live up to its commitments at the international level. The country enacted Water Prevention and Control of Pollution Act 1974. Under that act, bodies were created. Central Pollution Control Board was created. State Pollution Control Board was created. These boards were given multifarious tasks. Many functions were assigned to these boards, and they were expected to enforce the provisions of the act. Since they were expected to perform multifarious functions, there was a requirement of finances at the center as well as the state level. But as soon as the Water Act was implemented, it was found that there is dearth of finances, or the state pollution control boards, they were not having adequate finances at their disposal. And in order to cope up with this problem, the Union Legislature once again got up to the occasion, and they enacted the present act, that is the Water Prevention and Control of Pollution Cess Act 1977. This act is complementary to the Water Act of 1974, and the main aim of this act is to levy cess and to collect funds and to provide these finances to the state and central pollution control boards so that those boards can function effectively. Well, students, the learning objectives of this paper is to inform the reader about the legal provisions of the Water Pollution and Control of Pollution Act, Cess Act 1977, to inform him about the procedure for levy of cess, how the cess is different from tax, how much cess is payable under the act, what shall be the procedure for assessment of the water cess, and what will be the procedure for payment of that cess, what are the penalties if the cess is not paid on time, and then if a person is aggrieved by the assessment of water cess, or if any penalty is imposed upon him, what shall be the appellate procedure, where he can file the appeal and how he is to file the appeal. This is what we are going to discuss in this module. Well, students, the scheme for presentation will be, we will be discussing the Act, the Water Cess Act of 1977, the assessment procedure under the Act, the levy of cess, how the cess is levied, what shall be the rate of cess, on whom cess is leviable, the fines and penalties if cesses are not paid in time, and the appeals. Starting with the introduction to the Act, as said, this Act was enacted to support the Water Act of 1974, so that the cess can be levied, which can be used by the central and state boards for discharging their functions under the Act. Just like the Water Act of 1974, this Act has also been enacted by the Union Legislature. So the Union Legislature enacted this Act to provide for the imposition of cess on usage of water by specified persons and authorities. Cess is not levied on everybody. Water cess is levied only on industries and authorities. This is a very small piece of legislation. It contains only 17 sections, and as we said, it was enacted as a complementary enactment to the Water Act, with the main purpose to facilitate the achievement of the objectives of the Water Act of 1974 by providing finances to the pollution control boards. This act came into force on 1st of April 1978. Now, before we deal with the provisions of this act, let us briefly discuss what is meant by cess and how cess is different from tax. We all know both cess and tax, they are levied by the government and they are compulsory payments. The payment has to be made. They are compulsory exaction of money by the government. But then, whereas tax is levied for general public purpose and we cannot expect any specific service from the government, cess is levied for a particular purpose. Cess has been given the meaning similar to the meaning ascribed to fee. Just like fee is payable for availing a particular services, cess is also levied for rendering a particular service or for a particular purpose only. We all know we have various cesses in this country. We have Swachh Bharat cess, education cess, secondary higher education cess, and in the same manner we have got water cess. Cess Act of 1974 is applicable to all states and union territories except the state of Jammu and Kashmir. It applies to all other states where the Water Act of 1974 has been made applicable. Since this act is complementary to Water Act of 1974, therefore this act does not define all the expressions, all the words which are used therein. Rather, it makes a provision that those words and phrases which are used in this act and which have not been defined in this act, they shall be given the same meaning as is given to them under the Water Act of 1974. Now, let us see who is liable to pay cess. Cess is to be paid by an industry or by a local authority. An ordinary individual is not required to pay water cess. This water cess is payable by an industry or local authority only. Industry is defined in the act to mean an establishment carrying on any operation, any process, any treatment or disposal system which consumes water and which gives rise to sewage effluent, but it does not include hydel power unit. That means any industry which carries on any operation where the water is consumed and where from some trade effluent or sewage effluent is emitted, except the hydel power plant. The act also applies to local authorities and therefore it defines what is meant by local authorities. Local authority means a municipal corporation, municipal council, cantonment board or any other body which is engaged in or which is entrusted with the task of supplying water. Before 2003, that means before the commencement of the Amendment Act of 2003, water cess was levied only on specified industries and the list of industries was specified in Schedule 1. But then the Union government thought it fit that cess should be levied on all industries which are using water, which are consuming water and which are emitting effluents. And therefore, the Act 2003 Amendment Act was passed. This Act has amended Water Cess Act of 1977 and it has made this Act Water Cess applicable to all industries. Earlier, as we said, up to 2003, only it was levied only on specified industries like ferrous metallurgical industries, non-ferrous metallurgical industries, mining industry, ore processing, petroleum industry, petrochemical industry, chemical industry, cement industry, ceramics, textiles, papers, fertilizers, power, processing of animal or vegetable products, including the processing of milk, hides, skins and agricultural products. And it was also made applicable to engineering industries. But however, this 2003 Act has made it applicable to all the industries which are consuming water, and therefore Schedule 1, which gave the list of industries, that has been removed from the Act of 1977 by amendments of 2003. As we said, that cess is applicable or is only two authorities. One is local authority or the industries, they have been made liable to pay cess. Everybody has not been made liable to pay water cess under this Act. And the payment of cess is linked with quantity of water consumed. If we look at the liability of local authority, the Act provides any local authority, be it a municipal corporation, municipal council, cantonment board, or any other body which is supplying water, it is liable to pay cess on the consumption as well as supply of water. If the water is supplied to an industry and that industry is liable to pay water cess on the amount of quantity of water used by them, then there will be no cess leviable on that local authority. To avoid double taxation, cess is to be paid either by the local authority for consumption or for supply of water, and if the water is supplied to an industry which is liable to pay cess on the water consumed by it, then that industry is liable to pay the cess, and on the supplies made to that industry, local authority shall not be liable to pay water cess. Similarly, if the local authority supplies water to another local authority and that local authority is liable to pay cess, in that case also the first local authority shall not be liable to pay cess under the Water Cess Act of 1977. If we look at the liability on the industry, then we find there is a Schedule 2 in the enactment. Now the Schedule 2 specifies the rates of water cess. Schedule 2 specifies the maximum rate of water cess. Up to this maximum rate, power has been given to the central government. That central government can fix the rate of water cess leviable on a particular industry, subject to the maximum rates specified in column 2 of the schedule, which is available on the slide. If you see, it is divided into 4 parts. The first part is dealing with those industries which are dealing with industrial cooling, where the water is consumed for industrial cooling or spraying in mine pits or boiler feeds. In this case, the maximum rate which is prescribed is 5 paisa per kiloliter. As we said, water cess is leviable is linked with the quantity of water consumed by the industry or by the local authority. The second category is when the water is used for domestic purposes by the industry, then the rate of cess would be, maximum rate of cess would be 2 paisa per kiloliter. If the industry is using the water for processing, whereby the water is getting polluted by way of easily biodegradable pollutants, non-toxic pollutants, both non-toxic and easily biodegradable pollutants, in that case the maximum rate of cess is 10 paisa per kiloliter. And where the water is consumed by an industry for processing and the pollutants discharged thereby, or water is getting polluted by pollutants like which are not easily biodegradable, which are toxic pollutants, or which are both toxic and non-biodegradable pollutants, in that case enhanced rate of cess is payable, that is 15 paisa per kiloliter is the maximum rate of cess which is leviable on that industry. However, we must keep in mind that under the Water Act of 1974 there was section 25. Now that section 25 put up an obligation on any industry which starts or commences its operations after the commencement of the Water Act of 1974. The liability was put up on the industry that it shall be required to get previous sanction of the State Pollution Control Board before any activity is commenced. Any industry which is likely to discharge trade or sewage effluents. So in case of existing establishments also, the liability was fixed under the Water Act of 1974 to obtain the sanction of the State Pollution Control Board. And whenever they make any changes in the point of discharge, in the quantity of discharge, in the quality, in the temperature, in the constituents of that discharge, they are required to inform the State Pollution Control Board and obtain the consent. If any person, any industry violates that section 25, that means it commences business activities without the previous sanction, or the sanction has expired, or the conditions in that sanction letter, consent letter, they are not complied with. In that case, Water Cess Act provides for levy of cess at the enhanced rates. If you see column 3 of this schedule, then in case of first category, where the maximum rate is 5 paisa per kiloliter for industrial cooling, in normal cases, in those cases where there is a violation of section 25 of Water Act, the rate goes from 5 paisa to 10 paisa per kiloliter. Similarly, for domestic purposes, where the normal maximum rate is 2 paisa per kiloliter, in case of an industry violating section 25, the rate goes to 3 paisa per kiloliter. Therefore, the maximum rates are prescribed in this third column of the schedule in case of those industries which violate section 25 of the Water Act of 1974. You see that all the rates in the third category of when the water used for the third type, third category, third purpose, then also the rate, normal rate is 10 paisa, but enhanced rate would be 20 paisa. And where the water is used for the fourth purpose, that is where the pollutants discharged are not easily degradable, biologically degradable, or which are toxic pollutants, or which are both toxic as well as non-biodegradable pollutants. In that case, the rate goes up from 15 paisa to 30 paisa per kiloliter. Friends, if we look at the provisions of the Water Act, we find, Water Cess Act, we find that under this act also, there is a provision for taking the consent of the State Pollution Control Board. Any local authority which is likely to emit, likely to discharge effluents, or which is already discharging effluents when the act has come into force, the act casts a duty upon that industry or that local authority to obtain the consent of the State Pollution Control Board. As we said, that the charge of or levy of cess is linked to the use of water. That means to quantity, the quantity of water consumed, that will be the unit for levy of cess under the Water Cess Act. Therefore, the act provides for measurement of the quantity of water used by the industry or by the local authority. And for this purpose, a provision is made in the act that meters shall be installed at the entrance where the entrance of that water supply connection. That means where water supply connection is given at the entrance, meters shall be installed. Those meters are required to be of prescribed quality and prescribed standards. Those meters, the reading of those meters shall be deemed to be correct. That means whatever reading the meter is giving, that this much water has been consumed by the industry or by the local authority, there is a presumption of correctness. However, if somebody can give evidence to the contrary, that the meter does not give the correct reading, and he has got evidence to that extent, then the genuineness can be disputed. Otherwise, unless there is evidence to the contrary, whatever reading is given by the meter, it is deemed to be correct. And if a person, an industry, does not install the meter, then the power is vested with the central government. It can get the meter installed at the entry where the water connection is given, and the cost of the meter can be recovered from that person. And for the purpose of checking whether the meter is giving the correct reading, whether the meter is working properly, and to take the readings, any officer of the state government can enter the premises at all reasonable hours, take the reading of that meter, and check whether the meter is working correctly. Liabilities have been imposed upon the cess payers. The act requires that the cess payer, that is the industry or the local authority, they are required to file a return in Form 1 specifying how much water they have consumed during the return period. Return is to be filed, monthly return is to be filed, and it is required to be filed before the 5th of the next month. Once the return is filed, thereafter the assessment officer, he is required to assess the amount of cess payable under the act. Whatever cess is payable under the act, that is required to be deposited with the state government, and the state government is required to transfer this cess to the central government by the 10th of every month. That means whatever cess the state government has recovered from the industry or from the local authority, the entire amount is required to be transferred to the central government, because it is a central legislation. If a return has not been furnished, what will happen? In that case, the power is given to the assessing officer, that the assessing officer can, after making such inquiry, he can assess the amount of water consumed by that industry or by the local authority, and accordingly can determine the amount of cess payable by the industry or by the local authority. Now let us see As we said, local authority is liable to pay, and any industry. Industry may be owned by the government, even that government owned industry is liable to pay cess. If we look at Union of India versus Rajasthan State Board for Prevention and Control of Water Pollution. Now if we see, and in this act, there was a power plant, Rajasthan Atomic Power Plant, that was situated in the state of Rajasthan, and cess was levied under section 6 of that act, under the provisions of section 6 of the Cess Act. The Rajasthan Atomic Power Corporation disputed the payment of cess on the ground that we are a corporation owned by the central government, and therefore under Article 285 of the Constitution of India, there is exemption to the properties of the central government from the payment of taxes to the state government. Article 285 of the Constitution of India exempts the properties of the union from state taxation, and on this ground the Rajasthan Atomic Power Corporation claimed exemption. However, this was overturned by the Rajasthan High Court. The Rajasthan High Court said that the exemption is available from taxes on union properties. This is not a tax on union properties. This is cess on water usage by a company. The court observed that the corporation, Atomic Power Corporation of Rajasthan, is consuming high quantity of water to push water post nuclear core. Hence, there is increase in the temperature of water, and when the properties of the water are changed, it means there is water pollution. And accordingly, the court said even the Rajasthan Atomic Power Corporation is liable to pay tax, though it is a central government enterprise. In order to incentivize the installation of water treatment facilities or water treatment plants or sewage and trade effluent treatment plants, the Act has incentivized the installation of these plants. Any person who installs any sewage treatment plant or trade effluent treatment plant, he is entitled to 25% rebate on cess payable by him. As soon as he installs this plant, 15 days thereafter, he can claim the rebate of 25% on the cess payable by him, and till the date this plant is kept in a running condition, he can claim the rebate payable under the Act. If we see under the Water Cess Act 1978, the quantity of water used by industries is to be prescribed. The maximum quantity of water to be used by the industries is prescribed. If the person who has installed this sewage treatment plant or effluent treatment plant, but then he is consuming the water in excess of the prescribed norms, he is not entitled to get rebate on payment of cess. If any person fails to pay tax, the person who is liable to pay tax, cess under this Act, but does not pay it within the time specified, then the penalties are prescribed under the Act. That is, he is liable to pay the amount of cess together with interest at the rate of 2% per month, even a fraction of a month. That means even if there is a delay of 1 day, he is liable to pay interest at the rate of 2% per month. If a person fails to deposit the cess, in that case, penalty can be imposed up to the amount of cess. That means if the amount of cess is 10,000 rupees and there is failure to deposit the cess up to the specified date, then penalty up to the amount of cess that can be levied. But before levying any penalty, natural justice requires that reasonable opportunity of being heard is given to the person on whom cess is liable to be paid. And if there is a sufficient reason for non-payment of cess, that reason is reasonable, then no penalty is required to be levied. If a person files a false return, deliberately, knowingly files a false return, or when he makes evasion of payment of tax, willfully he evades the payment of tax, in that case, that person can be imprisoned. He can be punished with imprisonment. The maximum amount of, or maximum quantum of punishment is 6 months, or in the alternative, court can also impose fine. Court can impose fine as a substitute for imprisonment, or court can impose both, that is imprisonment as well as fine of up to 1,000 rupees. And if the offense is committed by the companies, In that case, provision has been made, because we all know that company cannot be sentenced to imprisonment. Therefore, the provision is made in the act that in such cases, the person who is in charge of the company at the time when the offense is committed, he shall be deemed to have committed the offense along with the company. And therefore, he is the person who can also be punished with imprisonment. And if the offense is committed with the connivance of, with the consent of the manager, the director, the secretary of the company, in that case, these persons shall also be deemed to have committed the offense. However, if the person in charge of the company is able to show that he had taken reasonable steps to prevent the commission of the offense, or that he could not prevent the commission of the offense and he is not party to it, he has made all out efforts and he has exercised reasonable diligence, then he is not to be punished under the act and he shall not be deemed to have committed the offense. If any person on whom the penalty is imposed, or any person who is dissatisfied with the assessment order passed by the assessing authority under the Water Cess Act, if any person is dissatisfied either with the assessment order or with the penalty imposed upon him, he has a right to file an appeal before the appellate committee. This appellate committee is to be constituted of 3 persons. Then in that appeal, he has to state the grounds of appeal, the facts of appeal, and then appeal is to be accompanied by the copy of the assessment order or the copy of penalty that is required to be annexed along with the appeal. The duration for filing the appeal is 30 days. Within 30 days, appeal can be filed. 30 days from the date of communication of the order. However, if the appeal is not filed within 30 days, but it is filed within 45 days from the date of communication of the order, and the appealant can satisfy that there was a sufficient cause for not preferring the appeal, for not filing the appeal within the stipulated period, then the delay of 15 days, up to 15 days, can be condoned and appeal can be accepted. Appealant is also required to pay the requisite fee along with his memorandum of appeal. It is the duty of the appellate authority to dispose of the appeal as early as possible, as expeditiously as possible. And if any person is dissatisfied with the order of the appellate authority, appellate committee, then after the enactment of National Green Tribunal Act of 2010, NGT has been constituted, that is National Green Tribunal has been constituted, and second appeal can be filed before the National Green Tribunal under the Act of 2010. The Act has empowered the Union government to exempt any industry from the payment of cess if the consumption of water by that industry is below the specified quantity. Before granting the exemption, the central government is to keep in mind various factors such as nature of raw material used, nature of manufacturing process, nature of effluent generated, sources of water extraction, nature of effluent receiving bodies, and the production, the data, how much production is done, how much water is consumed per unit of production, and where the industry is located. Keeping into mind all these factors, the central government can grant exemption to an industry from payment of water cess. Therefore, students, in this module, we have learnt which authorities are liable to pay cess, how much cess is payable, how much cess is payable if an industry commits a default in complying with the provisions of section 25. That means it does not obtain the previous consent of the State Pollution Control Board. When the fines are leviable, if the interest is not paid, how much fine is leviable. If you are dissatisfied with the order of the assessment authority, then where to file an appeal, how to file an appeal, and where second appeal can be filed. Thank you.